had, I was about to say the pleasure, but I would say more displeasure of having reviewed at least some of what Mr. Hales has posted online.
I found that to be incredulous understatement of the morning.
This is hearing number 4, which has spanned over almost 4 months now in Levy County Courthouse, where this judge, Craig DeThomasis, goes rogue as he's come down with the fever, black robe, power-hungry syndrome fever.
All right, good morning. I'm Judge DeThomasis. It is 10:02 a.m., January 23. This is the case styled as Preston and Hales. Cases 38-2023-DR416. We're here on several motions from both sides. Status conference last week. Court was notified that the limited notice of appearance filed on behalf of the petitioner was to address matters related to changing the date currently scheduled for January 26 to reconvene and resolve this matter. And respondent, or on respondent's behalf, counsel advised in part, I believe, that they were seeking a continuance or potentially for different reasons, wholly different reasons, and other matters related to that. And the court directed that the parties by 5 p.m. on Friday, January 19th, file their respective motions.
You'll notice LIEnette has a lawyer now because somebody was gullible enough, foolish enough to give her $7,000 to put down as a retainer for Joshua Silverman. Not only Silverman, but he's got another person on the other side of him. That person is blowing through money like crazy. And to date, as of right now, I have spent $76,000 just in legal fees on LIEnette. You say, Jeremy, why would you even share that? Because that's what I'm going after her and Crook for. That's the current liability as far as funding goes.
This matter is noticed for hearing January 18. 1 hour is set aside. I've got some preliminary comments. It'll eat into the time. I'm still going to allow and provide both counsel, each party, 30 minutes apiece to present their arguments, but I want to comment on a few matters.
Anybody shocked that Craig DeThomasis wants to burn up more time with his special orations that just go round and round and round, and the man does not know how to land a plane? That means end the conversation. His job is to listen, and that's not happening. Now, I also have to set the stage for you here. George is outside because Crook is outside illegally breaking the civil protection order again. And as we came in, I asked my lawyer, do you want to go out and escort George in, or should we have a deputy escort George in? This becomes important towards the end of this hearing because, as in all things in LIEnette's world, now her attorney is going to mirror exactly what I said openly before this started.
Petitioner's motion to continue evidentiary hearing, which is scheduled to be resolved and adjudicated today, was filed January 19th at 8:12 p.m. The respondent filed on 1/19 at 5:22 p.m. what's styled as motion for sanctions, including voluntary dismissal, attorney's fees, and costs and related relief.
The judge gave both parties the deadline of 5 p.m. And yeah, my lawyers were a little bit late, but her lawyer, oh my goodness, hours upon hours upon hours late. We were 22 minutes late. This becomes an issue for the judge. He's going to hammer down on everything, and he is mad.
The matters filed subsequent to that filed in effect today, really yesterday, specifically filed on January 22, Monday at 6:59 p.m., which is effectively today. The cover communication to my judicial assistant states, attached is the case law portion to go with the motion for sanctions filed on Friday. The fact is, what's attached to it does not contain even one case, one copy of a case at all, so it's not a case law portion. It's styled as a memorandum of law with no cases attached to it, but certainly some cited within it, but it is primarily an argument, and it's considered as such. And so we've got, and it'll come up later, we'll certainly address non-compliance with the directive regarding timing of filing documents, late filing, effectively this morning or 7 o'clock last night, filing additional argument. Counsel's got 30 minutes to present their case on both sides. The matter is this: January 26th is scheduled. Counsel for the petitioner filed what's styled as a notice of limited appearance on January 17 for the purpose of addressing a motion to continue the January 26th hearing. And it's clear to the court, and it should be clear to the petitioner, that if the court doesn't grant that relief, she may be without this counsel to represent her. And so prospective counsel, in a way, but who files a limited notice of appearance to address this issue, we're going to address here today.
Joshua Silverman files a motion to represent LIEnette as a limited appearance. What that means is he can be in court that day, and he's asking for a continuance because he can't be in court January 26th. Now, we all know this has already happened in the past. January 26th isn't going to happen anyway. They've dodged depositions 3 different times, both Crook and LIEnette. You've got my lawyer sending supplemental information saying it's case law. Now the judge is saying, well, no, it's a memorandum. Now it's a legal argument. He's using all these legal terms. Regardless, they dodged their depositions. They owe me sanctions and money, all my legal fees, $76,000 thus far. And now we've got an attorney that's showing up and saying, sorry, I can't be there for the final hearing.
That has been characterized in part, or part of the characterization in this argument, which in one part was called case law and really is not case law, and is styled as a memorandum, but really is wholly including extreme argument, quite frankly, that describes in part the filing of the limited notice of appearance and the late appearance of an attorney potentially on behalf of the petitioner, but accurately today here on her behalf to argue a motion to continue. The length of continuance will be addressed if it's to be continued. But we've got language in this quote memorandum of law unquote, which is not really a memorandum of law, that states in relevant part as to this issue, calling counsel for the petitioner, who's really just trying to address the issue of calendaring, that it's a ridiculous excuse for an attorney who's coming into a case that's already scheduled for trial. Attorney Silverman is no exception to the principle that an attorney takes the case as he finds it. He should have declined representation if he couldn't fulfill his responsibility of being here on January 26th. He has no good cause. He's acting with contumacious disregard of the court authority, bad faith, willful disregard, gross indifference to an order of the court, conduct that evinces deliberate callousness, intentional abject interference with the orderly progression of the case, and going further and further.
Keep in mind that Silverman is Craig DeThomas's good buddy. So think about people you see me with at different times. You could be Travis Willis. It could be Rob. It could be Conkey. You could go on and on, right? And if somebody starts saying something about my good buddies, I'm not going to be too happy. These are people that I call up, that I hang out with. I'm like, hey, let's go get a meal. Let's go do this together. Well, that's the same for Silverman and DeThomasis. They're good buddies. And now all of a sudden in court, somebody's calling it exactly the way it is. It happens to be my legal representation and saying all these negative things about Silverman. Craig didn't like that too much. Careful there, Judge. Your bias is showing.
And I point that out because I want it to be addressed by both counsel that the record actually shows that on November 29, when the respondent was represented by counsel Mark Feather.
I can't believe it. Hearing number 4, and now he's going into a whole thing about Mark Feather again. We've heard it in hearing number 3. We heard it. Hearing number 2. We heard it. Hearing number 1. He doesn't like Mark Feather, but the rest of the community, the county, the world loves this man, except for Craig, the judge. But that's okay because he likes Silverman. So everything's going to be unbiased. Everything's going to be impartial in court, right?
Mark Feather, when offered an opportunity to reconvene the following morning at 9 a.m., and I'll get into that, his misrepresentations to the court, which gained his client the first of many continuances, misrepresented why the continuance is necessary. The court relied on the misrepresentation, granted the continuance. And then when the court scheduled it for the following week, and Mr. Feather represented no objection to that date, and the court said, this will be a priority, it's going next week. There was no pushback, there was no judge, but I might have something.
There's no pushback because my attorney's back is to the judge. He's talking to me about calendaring and scheduling, and then the judge adjourns without us knowing. That's why there's no pushback. And let's be very clear. As he continues to say Mark Feather misrepresented, basically he's calling him a liar. Mark Feather never misrepresented anything. Mark Feather told the truth. He said, I had to be in Ohio to deal with issues in the courts. He didn't say I was in a court hearing. He didn't say there was going to be a hearing that I was flying to. He said, I'm going to be in Ohio. And I was. And I have notary of all the documents. And then the court did go on to a hearing on January 10th, and these two are going to be found guilty, and there's going to be sanctions, and they're going to have a record. And yet judge wants to continue to go back to Feather and say that he somehow misrepresented, he lied, and he granted the continuance based upon the lies. Okay, so let's just say that there was miscommunication. The judge obviously did not understand. And the judge is the only one that said there was an actual hearing. Mark never said that. I never said that. Do you think he would have still granted the continuance? The answer is yes. He legally would have had to.
And then he files, again, another filing after hours.
This man only complains about my representation filing late. Silverman filed over 3 hours late. You won't hear one thing about that in this hearing.
Basically the Monday before the Wednesday hearing, a motion to continue that does nothing to point out that something came up between agreeing to the court date.
Who's misrepresenting in the court now? That would be the judge. And I'm not going to continue to flash back to all these hearings. They're on the channel. They're in the playlist. He's misrepresenting because nobody on my side ever agreed. He adjourned the hearing before any communication even happened. And that is not okay in a courtroom.
And the actual court date. But instead, in relevant part as it relates to today, Mr. Shockett, who was co-counsel to Mr. Feather, files a notice of appearance 24 hours and 20 minutes prior to the commencement of the hearing that was scheduled to conclude these proceedings on December 6th.
Huge difference in what my lawyer has done versus what her lawyer has done, okay? So in my case, the judge actually does not let us talk about scheduling, shuts it down, adjourns it, and then my lawyer, Mr. Feather, he has a medical procedure. He files for continuance, and Judge Craig DeThomas says absolutely no. I still have to show up to court on December 6th. I have to hire a lawyer within 24 hours. Within 24 hours for the hearing. You get that? Under 24 hours, I have to get a lawyer to now represent me at a final hearing. LIEnette's situation, very, very different. LIEnette has weeks before the hearing, hires a lawyer. He's there with a motion for continuance, but he still has 2 weeks. He has 2 weeks to prep. He has 2 weeks to get all the information. He has 2 weeks to get ready. Very, very different. 24 hours because he denies a continuance on my side because he hates, for some reason, this man hates Feather where the rest of the world loves him. And then he won't grant the continuance. I have 24 hours to find a lawyer who cannot get up to speed on this case. LIEnette has weeks. Silverman has weeks to get up to speed on this case. Huge, huge difference.
And so for counsel, and this is concerning to the court, for counsel to describe the actions of an attorney who steps in with a limited notice trying to address the limited issue of the calendaring of the event that's now scheduled for 26, which he's already told the court, I can't be here, but can you allow me to be heard as to that matter? We have an attorney calling that bad faith, willful disregard, indifference, unprofessional, intentional, abject interference. And nonetheless, we're dealing with current co-counsel of the respondent who 24 hours and 20 minutes took on a case that he knew he could not be prepared for, and he filed another motion to continue, which would have been about the third motion to continue, if not the second, depending on how you look at it, on behalf of the respondent. And so I would just suggest you all evaluate the context in which we are brought here today and keep the extraneous, unnecessary name-calling and characterization when the record evidence establishes that the court accommodated current respondent's counsel when he needed a continuance because he said he couldn't be prepared, because he got into the case knowing the case was scheduled, and he came in as co-counsel to a lawyer that told this court on November 29, somewhere between 4:50 p.m. and 5 p.m., Judge, I only need about 15 more minutes to conclude the entirety of my case.
Here we go again. We got to hear about how much he doesn't like Feather. And did you hear? He's trying to take away name calling. I'm pretty sure that is a First Amendment right. It's protected speech. Not to mention this case could have been resolved in 15 seconds. It does not meet the statutes of the state law, period. And here I am, over $76,000 into it. And at the tail end of it, looking at a lawsuit against the state for everything this judge has done to me.
I found that to be incredulous understatement of the morning.
Incredulous. Why doesn't Craig DeThomas just say, listen, I'm not impartial. Listen, I am biased. He doesn't have to say those words. He's literally telling it to us right now. This is insanity. No judge in the right mind. We have judges watching this on a daily basis. Lawyers have never seen this. Paralegals have never seen this. This man is rogue and out of control.
I don't know of a lawyer who could have, because he said he needed to present 2 additional witnesses. He needed to cross-examine the petitioner, who at that time took about 2 hours to not even get through with her direct testimony. And he didn't even address whether he was going to call his client and or maybe forgot whether he was going to make legal argument to the court. There was no way anyone, after this judge has spent 40 years almost on a daily basis in a courtroom, could have done that in 15 minutes. But in that context, current counsel, co-counsel of Mr. Feather, Mr. Shockett, took the case and said he couldn't be ready because he only had 24 hours and 20 minutes.
Just a heads up, we're going to have to hear this all over again and again and again in the final hearing as well.
And this court again accommodated the respondent. I want you to keep that context in mind. The court's taken 12 minutes of your time. Mr. Silverman, it's your motion that's first up on the docket.
Yes, Your Honor. Well, firstly, that's what I want to address. The first thing I want to note is I saw Mr. Shockett reference in his email to the court on Friday, and the court just referenced it. a 5 p.m. deadline on Friday. I'll be candid, I don't recall from I remember the court saying we had to file by Friday. I don't recall 5 p.m. If the court said it, I do apologize. I don't fault Mr. Shockett for filing after 5 p.m. The initial motion he filed. Obviously I filed mine 7-something p.m., but both were filed on Friday. What I do object to is Mr. Shockett's motion being heard today. The reason I object to that is when Mr. Shockett filed that motion, forwarded it to the court on Friday, he indicated there was additional authority, additional information he wanted to include. As the court noted, that was not filed with the court, styled as a memorandum of law until, I believe, 7 p.m., 6:55 p.m. Yesterday evening. So it was filed almost 2 hours after the close of business, the evening before a 10 a.m. hearing the following day. I don't engage in trial or hearing by ambush. I respectfully ask the court to decline to allow Mr. Hales and his counsel the opportunity to do the same. Candidly, I had a rather full calendar with my family last night. I did not have, well, I've read what was filed last night. I've not had the opportunity to go through it in full and to pull all the cases and read everything. I therefore object to it being heard today. We can reserve for another day the arguments I have on the fact that the motion or whatever it is completely unfounded, fails to cite relevant law, and the law that I have been able to review thus far seems to indicate it doesn't support what they're asking for. But I am before the court on a limited basis, pursuant to the rules of family law procedure, asking the court to continue this Friday's hearing. Contrary to the, as the court noted, rather bombastic assertions in the pleading filed yesterday evening, I have done what I think is the appropriate and ethical thing to do here, because when Ms. Preston contacted me, I knew I would not be available this Friday. I will not make a full plenary notice of appearance in the case if I know I'm unavailable for a trial or hearing date that's already set. That is why, pursuant to the family law rules of procedure, I have filed a limited notice of appearance, asking this court to consider continuation of Friday's hearing. As the court correctly noted, if the court denies the continuance, I will not be able to represent my client on Friday, and Ms. Preston is fully aware of that. If the court denies the continuance today, I imagine the court will be getting from me a motion to withdraw, a stipulated motion to withdraw before the end of the day. With that being said, the court has laid quite a bit of the record already. This case has been previously continued, I believe multiple times at the request of the respondent and or his counsel. I have not yet obtained the videos of the court proceedings, although I've had, I was about to say the pleasure, but I would say more displeasure of having reviewed at least some of what Mr. Hales has posted online.
Wait until he sees what his own client has posted online. Not hundreds, thousands upon thousands upon thousands of pieces of evidence of what she's posted online. And it sounds to me like we just picked up a new fan.
And there are excerpts of that court proceeding online, which I understand is the subject of another proceeding in this case next Monday.
What Joshua here is referring to is we had posted hearing number 1 and hearing number 2 before this hearing number 4 online. And those videos were unredacted. Now, I hope you understand you have to have personal or private information to have something redacted. Here's what he doesn't know. The redacted and unredacted videos are 100% the same. So if you say redacted video or if you say unredacted video, they mean the same exact thing, period. So the courts went after Feather, my first attorney, saying you gave Jeremy unredacted video. Well, it doesn't matter. The unredacted is the redacted because there is no redactions in 4 hearings so far. Not 1 second, not a half a second, not a millisecond of any redactions at all. Not to mention it's all public record. How much of the Johnny Depp Amber Heard trial was redacted? Oh, the OJ trial was redacted. You know, most courtrooms have a live streaming video nonstop. Just because Levy County is 50 years behind doesn't mean this isn't public information. And there was nothing wrong and nothing illegal about us posting the video. Redacted, unredacted, all the same thing. Exact same public information video. Anyone, absolutely anyone could have posted it.
I think that on an equitable basis, Your Honor, as I point out in the motion, both parties are entitled to representation by counsel. This court has previously continued this case at the request of Mr. Hales so that his counsel could be accommodated. I'm asking the court to do the same in this case so that my client's counsel, potential counsel, can be accommodated. This is obviously a complex case. There are issues related to the Fifth Amendment. I think those are, I point that out in my motion to continue. Mr. Shockett raised it in an entirely different manner in the document he filed last night. Regardless, I am aware from the state attorney's office that there are criminal allegations against both of these parties.
Criminal allegations he was referring to is violation of civil protection order from Ohio or temporary injunction in Florida. Now, there have been no criminal offenses on my part. So any allegation she made went to the state attorney. The 30 days has passed. They're all gone. Nothing happened. She and Crook are still under investigation.
And so the stakes are somewhat higher than they might be in another civil case of a similar character. And so for the reasons I cite in the motion, Your Honor, it is very important that my client be represented by counsel. The case law that I do cite in my motion clearly stands for the proposition that continuances should be granted when reasonable and when not overly prejudicial to accommodate a litigant's request to obtain counsel in the context of injunction proceedings. And that is precisely what we are asking the court to do this morning. It is not, although this is a somewhat complex case, this request is not really complex, and so I'm otherwise going to stand by what's in the motion, and I think it clearly sets forth a reasonable and quite frankly compelling case for a reasonable continuance of Friday's hearing.
Thank you, counsel. Let me just ask you before I turn to respondents' counsel, with regards to the length of continuance, obviously the court has to weigh any potential prejudice to the respondent who has currently a temporary injunction in place that has been modified effectively on 2 occasions by this court in conformity with the Second District Court of Appeals opinion. That's the most recent modification, issued 12/29. This court, in conformity with that, modified it to his benefit to some extent.
To his benefit for some extent? I got my First Amendment right back. My constitutional right back. That's not a benefit. That's a guarantee for every individual who has residency in the United States. And, oh, wait, he gave me access to all my property. Oh, I forgot. That's not a benefit either. It's a legal right. He took my legal rights away. There is no benefit he gave back to me. He illegally took my rights away. And yes, I will be taking this up with the state of Florida.
But obviously the court needs to weigh the length of the continuance in light of the totality of the circumstances, which I'll discuss at a relevant point here this morning. And so give me a sense, for instance, the case can be continued to the following week. It could be 2 weeks. Give me a sense of what you think you need to be ready and prepared. What really becomes, just in short, day one was continued, and despite offering to reconvene the following morning, November 29 to November 30th, and the respondent, as I mentioned before, asked for longer time. When we reconvened early January, there was a bomb threat in the middle of the hearing, and thus we did not complete that day's events, and so we're scheduled for the 26th. So in effect, it's the third day of the continuation. And I understand that you want to obtain copies of the court proceedings, so just give me a sense what you think the time frame reasonably would be for you to be prepared.
Obtaining copies of the court proceedings is not, Mr. Lanier, my paralegal, is already started working on that. I don't anticipate I'll have any difficulty with that. I don't think any of the other business directed to Mr. Feather applies to me or my office, so we shouldn't have any, I should have those in the next couple of days. I do intend to depose Mr. Hales, and I believe that can be accomplished in short order, probably within the next 10 days. When we get to the appropriate part about any motions they're bringing with respect to discovery, which again, respectfully, I don't believe are properly before the court today, I believe that Mr. Hales, through counsel, if he can properly serve Mr. Cook, with a subpoena, has the right to depose Mr. Cook, so I know he intends to take that deposition.
You paying attention to his words here? If they can properly serve Crook. So Crook was already served once for his deposition. He dodged it. And now here in court, Silverman's saying if he can properly be served. Well, here's what happened the second time he got served for his deposition. Process server comes back. Crook goes, "Ha ha! This is the second time you haven't given me my check." Oh my goodness, the guy is so freaking stupid. He tells the process server exactly what he's doing wrong, what Silverman is talking about. It's a $5 check that he gets process served. And if he doesn't get his check, I guess hyper technical, this is going to be a word that's going to come up in this hearing, he's not officially, technically, properly served. The guy is so stupid that he tells the process server, "Ha ha, you screwed up again." So the process server gives him the check and he's got to go to his deposition, which spirals out of control. And we'll get to that in another video.
As to a further deposition of my client, again, when we get to the appropriate date and time to hear that motion and the memorandum or whatever it is that Mr. Shockett filed last night, we could have a long discussion about the fact that it has improperly included communications between his office and mine in violation of the Florida Bar Rules of Professional Conduct. We can talk about the fact that he left out the fact that I have made a motion for 12.310D to terminate or limit my client's deposition. We can talk about the fact that it was improperly noticed. It was taken as a video deposition when not properly noticed as such, and then Mr. Hales pasted the video of the deposition all over YouTube. We'll get to all that. I don't expect that he's going to be permitted to depose my client any further, but he does have an opportunity, if he can serve Mr. Cook properly, to take Mr. Cook's deposition. So I figure we
Judge, none of this is relevant to the motion to continue, but
well, and so
Because I'm asking him what needs to be accomplished.
what he's
between
saying,
now
what's
and then.
not going to be accomplished.
So
He's already-
we have 2 depositions that need to be taken. I believe we can get that accomplished in the better part of a day, if not an afternoon or a morning. So I would think at this point a 2 to 3 week continuance would be appropriate.
Okay.
So that's where I am.
I just want to get a sense, we'll narrow down that request. Mr. Shockett, let's first address the issue of why or why not should we address what was characterized late last night after hours as case law, which was not case law. It was titled Memorandum of Law, but really is an argument, which certainly you could make argument. We're here for argument on issues. But with regards to the laundry list of sanctions that you're seeking, there's an objection to hearing that today.
Sure, thanks, Your Honor. Good morning. I'm going to answer the continuance issue by giving a little history first. Obviously, let's start from the beginning. They already have effectively gotten a continuance. Your Honor recalls, she didn't appear for her. We were supposed to finish on January 4th. She was supposed to appear for her deposition December 21st. So was Mr. Cook. They didn't show up. They filed motions. She filed a motion to reschedule her deposition. She also filed a motion to not take Mr. Cook's deposition. The day of the bomb scare, Your Honor ruled that both of those depositions need to go forward. And we scheduled them here in open court on the 16th and the 17th. On the 16th, this is what's shown here. We'll address the issue whether this is ready for today, but you know what happened, Judge. They didn't finish the deposition. And we're complaining about the actions of opposing counsel before the notice of appearance. And I don't know of any rule that says you have privilege to say something to somebody in an email and you can't be shown to the court. That doesn't make any sense. So what you have here is we gave you a Facebook post and we also showed you some emails where before in their appearance.
You're arguing the merits of the motion.
Okay, well, I just wanted to point out that effectively they got a continuance because we didn't get our required discovery.
Well, the record reflects that the respondent got a continuance on November 29.
Absolutely.
It was the first continuance based on misrepresentations to the court, and got the benefit of that, to the significant high potential for detriment to the petitioner.
Here we go again. There was no misrepresentation. I've seen it. You've seen it. The world has seen it. There was no misrepresentation. I had to fly back Ohio, deal with Ohio court issues because of her and Crook, and there was a follow-up hearing because they broke the civil protection orders, because they violated, as he's saying, a high detriment to the petitioner. There's been no Jeremy breaking anything, violating anything. I don't make any type of contact with these individuals. I share truth. I repost what she posts. I don't communicate. If she's in town hall, she's there. If she's doing illegal things, I'm going to film for my own protection. And yep, it's going up on YouTube, because without it, guess what? There is no protection in this godforsaken courtroom with Craig DeThomasis.
Detriment not only because it's still hanging out there, but at that time it was hanging out there without a temporary injunction in place. And the court precedent and whole specter of weighing continuance with a temporary injunction is wholly different than one when there's not. When we came back, when you were appearing on the respondent's behalf, right at the outset, I said to you, well, now the court has to look at this differently, because intervening, there was a second, I believe, if not third, but second, I believe, supplemental petition, which resulted in a temporary injunction.
And here comes 100% proof. He's watching the videos. Hi, Craig.
And despite representations to the contrary, so that Mr. Hales is aware, when the court receives a petition or a supplemental petition as a matter of law, this court must accept what's alleged in the petition as true. Period. End of discussion. The hearings decide if it's true and if it's competent substantial evidence. But the court must accept it as true. So despite allegations that the court is accepting what she says, yeah, as a matter of law, when it's pled in a petition or a supplemental petition, why? Because the court must do so. That's plain and simple. There's no choice in that.
I'm guilty because a pathological liar is telling lies. A life of lies, not just here in Otter Creek, all over. Her entire life is littered with the same things. Her own children will be giving witness, testimony to this is what she does everywhere she's ever been. And here I thought in court you were innocent until proven guilty. But nope, the judge, Craig DeThomasis, who's not allowed to watch the videos, shows his hand. He's absolutely watching the videos because, contrary to the way it's been portrayed, he has to take it as truth.
When we get to hearing, the court can reject or accept any or all testimony of any witness.
Okay, that's a great point. I want to just touch on that.
Hang on.
Yeah.
That's the second motion to continue that you argued. The respondent's third motion to continue, so that was on 12/1 at 5:56 p.m. The respondent's second motion to continue. Respondent's third motion to continue was 12/5 at 12:53. Respondent's fourth motion to continue was the January 4th proceeding.
Well, that was in conjunction with a motion for discovery violations of not showing up for their depositions.
I hear you. I know why. I've got institutional knowledge of why, but
Every case, every lawyer, I took the case just like Mr. Silverman. We take the case as we see it. I got short notice, and I said I'm going to ask. You know, I'm not prepared, and I appreciated Your Honor doing that. But this, I'm just pointing out here that this is a continuance. What
I did as a matter of law was to provide due process to Mr. Hales, your client. I wasn't going to deny him that.
Okay.
And so my question is, why are we suggesting Ms. Preston ought to be denied counsel?
My attorney had less than 24 hours to prepare for the final hearing. Her attorney has had weeks, multiple weeks, a week before this hearing and a week after this hearing. Huge difference in regards to preparation.
I'm not. I'm saying the opposite. Effectively, they've gotten it already. By her deposition not continuing, the Nettles case, Judge, we have to have discovery, and it didn't finish. Mr.
All right,
Cooks,
let's put it in this context.
Okay.
Everything's about context. Your co-counsel, current co-counsels to this day, Mr. Feather, represented he could complete the case in 15 minutes.
Are we seriously doing this again?
In hindsight, in error, this court regretfully allowed the deposition of Ms. Preston to take place in the first place.
In other words, I'm biased. In other words, I'm partial. In other words, Jeremy, you will not get a fair trial. In other words, I'm going to deny not only your freedom of speech, not only your access to your property, not only to drive on a public road to access your property, now I'm going to deny due process in the court of law. Who does this man think he is? And how in the world can he still, to this day, be a judge anywhere in the United States?
You're effectively taking a deposition of a litigant who in the middle of her direct testimony is stop, we want to now take her deposition. I regret approving that.
And yet he approved my deposition. You can't have it one way. It has to be for both. Equal opportunity, due process.
It's my understanding from representations of counsel, and we've got a record potentially of what, but it seems to me that process, which has resulted in, we'll fill in the blank, number of hours of deposition, which you're now saying was unsuccessfully left incomplete, has now, I just heard from Mr. Silverman, also been published to the internet.
Video that I own and can do what I please with. As a matter of fact, maybe today I'll sell it to A&E. They keep begging, but Netflix is in that battle with them as well. Maybe I'll give exclusive rights to Netflix. Then maybe Judge DeThomasis can go after Netflix.
In addition to your co-counsel, in violation of the Supreme Court Administrative Order, SCAO 11-222, and in violation of AOSC 11-22, and in violation of our Chief Judge's Administrative Order 1.14, version 2. Despite that, he requested and obtained unredacted copies of the 1129 and 12-6 proceedings, and is now answering to contempt charges from the Chief Judge, since it's his administrative order, about what then ends up being disseminated and published on your client's YouTube channel.
Understood.
And so that's another consequence of there being additional time. And now I'm hearing this morning that a deposition has been provided on YouTube.
Yep, the unredacted version is the exact same as the redacted version. Exactly what you're seeing right now. Is it redacted or unredacted? And yeah, you will see the rest of the deposition for both LIEnette and Crook. And this judge is about to go off the hook. I've never seen a judge so mad in court.